Hey everyone, if we're meeting for the first time, my name is Vojchehoske and welcome to the channel. So in today's video, I'm going to update everyone on the status of Nebraska's wholesaling law. Now, we know that in July of this year, Nebraska's new wholesaling law went into effect. Part of that law tasked the Nebraska Real Estate Commission with doing two things, really. Number one is they are the enforcement agency that's going to make sure compliance. Number two is they're the agency that's tasked with writing the rules and regulations. We have the law, but then there's a whole body of rules and regulations that are going to be developed around that law. Now, I think most of us in the industry, not only the wholesaling industry, but the real estate and sales industry as well, I think we all thought that the commission would have completed their work by the August commission meeting, and then they could vote on the new rules and regs, and we'd all know how these things are supposed to transpire. However, the August Real Estate Commission meeting came and went, and they still have not finalized the rules and regs. So what I did is, after the August meeting, I called Director Greg Lemon. He is the director of the Nebraska Real Estate Commission, because I really wanted to get kind of an outline or framework of what are wholesalers and what are the real estate agents representing wholesalers in those types of transactions supposed to do. How do we move forward? Because wholesaling transactions are not illegal. They are still very legal. That's the first thing. Second thing is the law only regulated the marketing of the wholesaler's equitable interest that they have in a contract. That's it. But there is a third component that has really complicated the rule writing process, and that is the Nebraska Supreme Court, in a case, basically said that a wholesale transaction must be listed by a real estate broker. And I'm not going to go into details why that is the case. It'd take too long, but it's a really complicated thing. And then you throw in the fact that, if it has to be listed with a real estate broker, if the equitable title, the equitable interest of the wholesaler must be listed with a real estate broker, because that broker has to market that equitable interest, then who signs the agency disclosure? Who signs the seller property condition disclosure? These are the things that complicate this process. So Director Lemon basically said his plan is to have a final set of rules and regulations implemented sometime October, November timeframe. So in the meantime, what are you supposed to do if you're a wholesaler? What are you supposed to do if you are a real estate professional representing wholesalers in those type of transactions? Well, I'm gonna outline that in today's video, right? So first thing that came out of our discussion, number one, is a wholesaler enters into a purchase contract with the seller. That wholesaler has equitable interest. They cannot market their own interest on their own. There is no FSBO or for sale by owner exemption for the wholesaler. Now, in Nebraska license law, there is what we call that FSBO exemption. So if you own your own property and you are selling your own property or selling your property, you have two options. You can list it with a real estate professional, or you can represent yourself and sell it by yourself. And we commonly refer to that as a FSBO or for sale by owner. That's an exemption in the Nebraska license law. There is no exemption for the wholesaler marketing their own equitable interest. You must hire a real estate brokerage firm to market your equitable interest. Now, I've had several calls from wholesalers going, Paul, what about the fact that I already in the past have a relationship with an investor? So I find the property, I put it under contract, and I assign my interest to this investor. My question is, well, how do you notify that investor? And they usually say I either call them or I text them or email them. Under Nebraska license law, the definition of marketing is extremely broad. So Director Lemon's position is that even texting, calling, sending an email to an investor that you already have a relationship with is considered a form of marketing, and that you would be in violation of the new wholesaling law. So there's really no way around it. If you're a wholesaler and you want to sell your equitable interest, you must hire a real estate brokerage firm to represent you in the marketing of that transaction. That is objective, and there are no exemptions. All right, now the second thing I want to talk about is the listing contract. A common question that everyone's asking is, fine, we know it has to be listed with the real estate firm, which requires a listing contract. Who signs the contract? Is it the wholesaler? Is it the seller? Well, after talking to Director Lemon, he indicated that this case, the listing contract is going to be signed by the brokerage firm's representative, that listing agent, and the wholesaler, not the seller. Now, all of this may change when the final rules come out. This is all temporary, but as of right now, until the final rules come out or there's a change, the wholesaler signs the listing contract, not the seller. Number 3, what about that agency disclosure? Well, just like the listing contract, the agency disclosure is going to be between the real estate brokerage firm and their representative, such as the listing agent, and the wholesaler, not the seller. Once again, number 4, what about all those other disclosures? Wholesaling transactions do not exempt anyone from their statutory requirement to complete these disclosures. So typically we have 2 disclosures. We have the seller property condition disclosure statement, which is required by state law that the seller complete and have available to any prospective purchasers. So when the wholesaler and the seller enter into that purchase contract, the seller is required to generate a seller property condition disclosure statement, which they sign, and also the wholesaler who's signing that purchase contract must also sign that disclosure. The same is true of a lead-based paint disclosure if the home is built prior to 1978. Now, there are no exemptions to this. So, wholesalers, you need to make sure your seller is signing and you are signing the seller property condition disclosure and also the lead-based paint. Now, what about the assignee? So the wholesaler assigns their interest in the contract to an assignee, the person that's going to ultimately buy the property. They must also be party to these disclosures. So my recommendation at this point is you have the seller that signs the disclosure, you have the wholesaler that signs the disclosure as the purchaser. I would have the assignee also sign the same disclosure as the assignee. I get questions whether or not the wholesaler should generate their own form. And the answer is, I believe personally, this is not legal advice, but if the wholesaler does that, there is substantial legal jeopardy here because the statute, not only for the seller property disclosure, also the lead-based paint, they must be completed by the title holder, the person that has legal title. The wholesaler only has equitable interest, so they don't have the authority to sign as the seller. So make sure that that assignee gets those disclosures and that they execute them as well. Brokers, make sure that you are getting fully executed disclosures. Otherwise, you need to get involved and make sure that it's done accordingly, because you're on the hook for this as well if the wholesaler is not complying with this requirement. Today's video is sponsored by my YouTube channel, so do me a favor and give this video a thumbs up and subscribe to the channel. Please subscribe to the channel. It's so important so I can grow it and bring this awesome information to other people as well. Hit that little red button for me and click that notification bell as well. Thanks. All right, number 5, seller acknowledgement. So it is very common for the wholesaler to include language within the purchase contract that gives them permission to market their equitable interest and things like that. However, after my discussion with Director Lemon, here's my personal opinion that I think is an absolute must for all involved, especially you brokers. All right. I believe that a separate document should be created, and I would title it Seller Acknowledgement. And the seller must sign this. The wholesaler cannot sign this document on behalf of the seller, even if there is some type of power of attorney that gives them the authority to sign this. As a broker, I would not accept this. And there's a lot of reasons why this needs to be done. I'm not going to go into the details now. I think they're going to be addressed in the final rulemaking. So seller acknowledgement, it's a form that should be generated, and here is the things that need to be on this particular document. First bullet point here, the seller is given the wholesaler permission to market their equitable title. The second thing that should be on this document is the seller understands that this is a wholesale transaction and the equitable interest may be assigned to another party. The third thing that should be on this form, and I guarantee you the wholesaler is not going to like this, but from a risk management point of view, I think both the wholesaler and the real estate professional should have this included. The wholesaler may sell their equitable interest for a price that is higher than the price agreed in the purchase contract between the wholesaler and the seller. Now, bullet point number 3, I guarantee you wholesalers are not going to like this, but it really doesn't matter. If you're a real estate broker and your agents are out doing these transactions and you're going to allow your real estate professionals at your office to do these types of transactions, then I would absolutely require that this bullet point number 3 be in there. The reason why I think you should have this in here is when the final rule is written by the commission, based on the Supreme Court case that's out there, every wholesaler is, I guarantee you, going to need to have a real estate license to even engage in these wholesaling transactions. Right now, you don't have to be, but you have to use a licensed agent to market your property. I do believe, based on the principles that are involved in the rule writing, that once it's done, the wholesaler themselves will have to be licensed. And that's only a couple of months away. So first thing I would tell you is you wholesalers, get licensed as soon as you can if you're going to continue. And number 2 is, let's start complying as a licensee now, and that's why this is in here. Brokers, this is also intended to save your backside should a complaint be filed or a lawsuit be filed. All right, so let's look at bullet point number 4 here. Bullet point number 4 is an adverse material fact issue, all right? So if you are a wholesaler and one of two things is true, either you have no intention of closing or even a possibility that you're not going to close on the property, or you do not have the financial means to close on the property, then you must disclose that to the seller. This is especially true if you do not have the financial means to close on the property. Remember, that purchase agreement, for it to be valid, has a closing date that's been indicated in that contract. That means contractually you're obligated to close on it. If you don't have the financial means to do it, that must be disclosed. Even if you have a provision, in my opinion, talk to your broker, you listing agents, talk to your broker, and they can structure this however they want. But my opinion is, even if the wholesaler has a contingency that gives them an out where they can cancel the contract at any point, that still does not relieve your duty, in my opinion, just my opinion, to not disclose the fact that you do not have a financial, the financial means, the resources to close on that property. And now the final bullet point here, after my discussions with Director Lemon, it is my belief, in my opinion, that even though all of these things may be included in the purchase contract, Director Lemon seemed to indicate that he wanted to see this on a separate document, and that's good enough for me to keep me out of real estate jail. It's going to be on a separate document. The other thing is, this is not a document that the wholesaler can sign on behalf of their seller, even if they have a general power of attorney. Now, they may legally be able to do it in some way, but as the real estate broker, I am not accepting that. It has to be the seller's signature, not a power of attorney signature on behalf of the seller. Number 6, real estate agents, please make sure you get a copy of the wholesaling purchase contract, because we as real estate professionals, we have to be able to prove that the wholesaler does in fact have equitable interest. Number 7, I want to talk about the MLS issues and the clear cooperation policy. So if you're a realtor member, clear cooperation is a policy that requires that if you make any details of a listing public, then it must be put into the MLS within 24 hours. Otherwise, the MLSs are going to fine you. Now, the Great Plains Multiple Listing Service has a policy that prohibits the anyone putting equitable interest transactions in the MLS. You cannot do it. I don't know about outstate Nebraska MLSs or Southwest Iowa and what their policy is, but they all have to comply with the clear cooperation. So at least if you're in the Great Plains Multiple Listing Service, not being able to put that transaction in the in the MLS is going to put you in jeopardy with the clear cooperation policy. However, my personal opinion is, and you brokers need to talk to the MLS about this, I don't see how the MLS could actually fine you for violating clear cooperation when it's their own rule that is prohibiting you from putting it in the MLS. I just can't see that happening. That's my opinion. Brokers, you're going to have to vet that with the MLS if you're going to do these type of transactions and you're a realtor member. Number 8, one other thing I think that is important for brokers. No POA executed document should be accepted. Now, what I'm seeing in the industry is a lot of wholesalers having the sellers sign not only limited but general power of attorneys that give them the authority to sign any documents on their behalf. Great, except not at my real estate company. If you are a real estate broker and you're allowing this, you are subjecting yourself to substantial legal jeopardy. I'm not an attorney, but I'm standing behind that one. So if there is an extension on that wholesale contract, or the wholesaler is signing those disclosures on behalf of the seller via a POA, do not accept it. Do not list it. That's my personal opinion. You can do what you want. I just think you're asking for serious trouble if you do that. Then last but not least, bullet point number 9 here, auditing issues. I get the sneaking suspicion based on my conversations with a few of the principals that are involved in this process that the Real Estate Commission, when the final rule is written, that they're going to require 100% of the wholesaling transaction files to be audited by the commission auditors. Right now, it's kind of a random draw. They'll come in and say, I want to see these 50, real estate transactions, but I do think they're going to want to see 100%. So start preparing for those audits today. I'd keep them separate from your traditional real estate transactions. So when the auditor shows up, if they ask for them, you have them. Now, do me a favor here. If you know anybody else that's involved in wholesaling, or you know another agent that is doing these, or they are listing these type of transactions, please forward this video. My goal here is to try to educate everybody and keep everybody out of real estate jail as this process continues to unfold. Once the final rule comes out, or if there's any interim changes, I will bring them to you. But I wanted you to be informed. That's the whole purpose of this channel. Stay informed, join our community, subscribe, join our email list, and I'll see everyone in the next video.